Hello, my name is attorney Masa Sam Foray, owner and founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to talk to you about all things related to Illinois family law. So today's question is, my wife is threatening to move out of state with my children. What can I do? So it used to be that any removal out of the state of Illinois was unlawful without prior order of court or an agreement of the parties. That was when we used to call a move out of state a removal. So think about that scenario. Illinois is a very, very large state. So somebody living in Chicago who then moves the children down to Peoria or further down to Carbondale would still be within their rights as long as they were still living within the border of Illinois. So a couple of years ago, the courts realized that that's unfair. It's inequitable. There were lots of people who were being taken out of their children's lives and did not have ready access to their children because people were moving as far away as possible to the far corners of Illinois and saying, hey, I'm still within my rights as a custodial or residential parent because I'm still in the state of Illinois. So now the issue of removal is now what we call relocation. So relocation changed not only the name, but it changed the parameters for moving from one residence to another. Now under section 609.2, which deals with the relocation of children, parents have to give written notice with any intent to move more than 25 miles from their current residence. Meaning, if you currently resided in Naperville and you wanted to move to Olympia Fields, or you wanted to move to Gary, Indiana, but you lived on the south side of Chicago, anywhere within 25 miles, as long as you were within 25 miles of your present residence, you would not have to give notice to the other side and you would not have to get court approval. And there are a lot of people who commute between Cherville and downtown Chicago. There are people who commute from Wisconsin, from Kenosha, to working in the north suburbs of the Chicagoland area. And so this relocation statute just, was modified essentially to talk about the practicalities of living, particularly in the Chicagoland area or living on any of the borders between Illinois and our neighboring states. Nevertheless, under 609.2, it talks about what needs to occur if notice is given, but assent is not given from the parent who is not moving. If assent is not given by the parent who is not moving for your move with the children or your relocation with the children, then what you need to do once you have received this written notice from the parent who wants to move is you would need to go to court and file a motion to bar them from relocating with the children. So in this particular scenario, if your wife was threatening to move but she had not served you with written notice 60 days in advance of her intent to relocate, or if she served you with the notice to relocate 60 days before or more, but you did not agree with it, then you could go into court and you could file a motion to prevent her from removing the children. If nothing had been filed in court yet, so this is your wife, meaning you guys are not divorced yet, there has been no entry of, a final judgment for dissolution of marriage. Maybe perhaps you two have just been separated and talking about divorce, but you're not under the jurisdiction of any judge because there's no case that is pending between the two of you. Once a case is filed, meaning as soon as a case number is assigned to your case and as soon as a judge is assigned to your case and it is an active case in Illinois, then an automatic stay issues. And that automatic stay applies for all family law matters. So you don't need a separate order for your particular case. That automatic stay essentially says everything stays the way that it was at the time that this, divorce was filed, unless there is an agreement by the parties or unless there is an order by court. So if your wife is threatening to move and nothing has been filed in court, my best advice to you would be go to court immediately and file your petition for dissolution, or go to court immediately and file an emergency petition for temporary restraining order, or go to court and file your emergency petition for to stop her from relocating with the children more than 25 miles away from her current residence. The bottom line is courts are very, very interested, and in fact they are tasked and they are mandated to make sure that they keep family units intact, regardless of whether or not a divorce is going on and regardless of whether or not the two parents have separated. Because it's generally understood that it's always in children's best interest to have access, and ready, easy access, to both parents, unless there is an exception, unless one of the parents poses a harm or a danger to the children.